Mediator. I began my mediating career in Canada, where I first joined the Canadian Forces. And after being posted to Cyprus in 1978, my interest in mediation peaked. As a peacekeeper, that's mostly what we do, is mediating between the two opposing forces and try to get some kind of resolution before it gets to the UN, where at the time it will take days before we get their resolution. So after my stint in the military, I went back to university and I trained in law. And lo and behold, mediation really got to me then. I remember my first mediation was with the Provincial Court of Alberta. We had started the mediation program in 1995. We started the mediation program. So shortly after I finished my training with the LESA, the Legal Education Society of Alberta, I was one of the first to be on the Court Annexed Mediation in Canada. At that time, I mediated 12 successful cases in my first year. And while I was going back to study political science, I met my wife, who was from Kenya. I asked her to get married, and she said another one condition, and that condition was that I moved to Kenya. So I happily packed my bags and moved to Kenya. When I got to Kenya, I searched for opportunities in mediation, and there was practically none. However, the interest was there with individuals such as Justice Joyce Aluwach and later on Justice Nyamu and Mr. Gross. So I went through the channel from Justice Aluwach to Mr. Nyamu to Mr. Gross, and I got my first mediation with Mr. Gross in 2001. And since 2001, I've been just struggling and trying to make it happen until 2010, when the Constitution came out. Then I saw an opportunity where we can now promote mediation, or ADR, and with my experience, I thought that I could also train in mediation. So I started some training, and I started to promote the word or preach mediation.
Wow. Yeah, thank you for elaborating that, Johnny, because it's important that people understand before the 2010 Constitution, mediation was not as practiced widely in Kenya as maybe I can say right now. And we are still trying, right?
We're still trying, but we'll get there.
Yeah, for sure, we'll get there. So maybe now you could explain to my viewers what mediation is all about, because I'm sure not many people understand what mediation is about or its difference from negotiation and arbitration.
Okay, there's so many different definitions, but all mean the same thing as far as mediation is concerned. And I try to explain mediation as being a insertion of a human buffer between two parties that are trying to have a difficult conversation. Now, the human aspect comes into it, where as a human, I would like to know how much of a human effort you're putting into the mediation. And I'd also like to know how much of the emotional intelligence you're putting into the mediation. So you will find that, especially when you're involved with family mediation, there's a lot of emotions that are happening at the same time, and therefore it's difficult for people to have that conversation, which is a little bit different from commercial mediation, or arbitration, because in commercial mediation you're trying to really negotiate is sum. So there is no interest, as we say. So when that interest takes place in mediation, that's when you find that rise in emotions, and that's when communication breaks down.
Yeah.
So when we insert that human person inside the mediation, we're trying to get them to ease the tension between both parties so that that conversation or that communication can happen between the parties.
Yes, for sure. And I think one thing when you're training me, you say that we are not the ones who actually bring the solution, it's the two opposing parties.
That's right, and that is why we need that communication, because if they do not talk, then we cannot come to any agreement.
Yes.
So as a mediator, you are not imposing your position on the disputants,
Yes.
okay? Whereas in arbitration, you're making a decision for the disputants. In mediation, you having them have that conversation so that they can come to an agreement and work out their own solutions.
Yeah.
And you find that when people work their own solutions out, they're more apt to obey whatever
Yeah.
decision they come up with, rather than have a judge impose a decision on them.
Yes, yes, that is true. And now, as we move into, as we continue the conversation, in your opinion, do you think Kenyans have been receptive towards mediation, or what is your general perception about mediation in Kenya?
Kenyans have been very, receptive to the process. As I said before 2010, there was absolutely, well, it was very minimum. But since 2010 and it became part of the Constitution, you'll find that the Court Annexed Mediation has really sent people to mediation. But with that said, we have to go back to antiquity and look at the Kenyan society.
Yeah.
And where you'll find that mediation has been in the society for the last 2,000 years.
Yes,
Okay?
yes.
The chief there do mediation. As a matter of fact, I'm not sure of the statistics, but it is said that over 80% of cases do not even reach milimani. Okay? It's all settled by the chiefs and by the elders. It's traditional ADR.
Yeah.
So Kenyans are very open to mediation.
Okay.
Maybe the word may seem a little bit technical,
Yeah.
but they've been doing it when there's a wedding. You go talk to the parents. You do the harambe, and it's all mediation. It's all negotiation that is happening at the time. So yes, Kenyans are open to mediation.
Okay, and then maybe now you could explain to my viewers the advantages of mediation over litigation, because I know Kenyans are used to also taking each other to court whenever a dispute arises, and now maybe now you could say what are some of the advantages that mediation offers.
Okay. As you said, there are some Kenyans, I believe, mostly the Kenyans that live within the city, that are very litigious. And once the disagreement or once the discourse cannot happen, the first thing you hear is, I'm going to sue you. Okay? Well, fine. Okay? Go ahead and sue. However, stop and think of the process when you sue. Okay? Once you go to litigation, you will find that you get wrapped up in the, say, in the legal world.
Yeah.
Okay? You will start off by going down to a lawyer, putting in an affidavit. The lawyer will then put that into a petition. He will go to court with that petition and file those documents. But that is not for free.
Yeah, for sure.
Okay? That is not for free. So to begin with, you must have the money to go and put the down payment down to get in to even speak to a lawyer. And we are speaking here of access to justice.
Yeah.
Okay? Now, how can you get access to justice if you got to pay to even get in and talk to the judge, or to even get in and have your documents looked at?
Yeah.
So mediation can happen anywhere. Okay? As I mentioned before, we've been mediating in Africa for the past 2,000 years, And I'm sure you've seen some mediation back in our counties where the DO or the chief is under a tree and he's mediating with the people down there. So you do not need a big courtroom, you do not need a judge. So all that expense is saved in mediation. So mediation is cheaper. It saves you time. And there's so much more you can do with that money than give it to the courts. So that's the major difference between litigation and mediation. Litigation is cumbersome, the process is longer, and you'll find that even now arbitration that was supposed to alleviate those issues has now mirrored litigation.
Yeah.
So if you go to arbitration, it's almost the same thing. Okay, so once you go to mediation, I'm hoping for the day to come where you can pick up the phone, call a mediator and say, I'm coming in, and you have your issues sorted out in a mediator's office.
Yeah.
I'm not running to the courts. They already have a backlog that you will never believe.
Yeah, for sure. And I've actually remembered another advantage. I think we talked about it when you were training me, that actually mediation restores relationships.
Yes,
Yeah.
yes. And, I think I mentioned that because my background is family.
Yeah.
Okay? And family is number one in any society. So when the time comes for us to go our separate ways, that is fine, but usually the children involved. So once we have those children involved, we want to keep the relationship between mom and dad as amicable as possible so that amicability can be passed down to the children.
Yes.
Okay? And if you, I do not know if you went into this during training, if you go into the mental capacity of a child between 0 and 5 years old, you'll find that what the child sees inside the home is what he will portray. So if the child sees violence within the home, the chances are that once he grows up, he will also become an abuser. So mediation now keeps it amicable, keeps mom and dad talking. I mean, there is all kinds of things that need to be resolved. It's not only to get a document or a decree nisi and say, you know what, we're divorced. No, there's still education. University's got to be paid. School fees got to be paid. Sports got to be paid. The trips for school are got to be paid. So for all this to happen, for a child to have a well-rounded life, the parents have to communicate and they got to keep talking.
Yeah.
So mediation does keep that intact. Yeah. Whereas when you mediate in commercial, you look for a settlement. How much do I owe you? Okay, you owe me $2 million. Okay, I'll settle for $1 million. Give me my $1 million, and you go. It's over. I don't have to talk to you again after that. You see, so, and that is why I'm passionate about family mediation.
Yeah, for sure. And then maybe now we could talk about your experience in handling family cases. I know you've done a couple of court annexed mediation.
Right.
So now maybe you could share some experiences or instances or what you've learned.
What I've learned is that through the court annexed mediation is that usually when you get a file from the court, they have spelled out what the issues are. And they now give that to you to mediate. Okay? Whereas in family, you must have those emotions met, as I say. So you have to give each party a chance to relay their part of the story to you. And you'll find that the way dad sees things is different from the way mom sees things. Okay? So you have to now find out when the right time is for that discourse now to happen between mom and dad. What you'll find as soon as they come in and they sit, they'll give each other their backs. They're not going to talk. Yeah. So you've got to now get them to loosen up so that they can begin the mediation, and now you'll have a successful mediation. Yeah. Otherwise, you cannot mediate a family mediation without having those emotions met. So once the court gives you the issues, they will spell out the issues as what needs to be. If you go directly to those issues, you'll find that you'll miss the whole point, and your mediation becomes that much more difficult now because you'll never get to the root of the problem. And in family, it's a collaborative effort. It's not only the mediator and the parents that are meeting. You've got the psychologists are involved. I mean, the children are going through trauma, so you need to get your psychologists involved. You need to get the children's doctors involved. You need to get the school involved. So you got to give people the chance to go and deal with these issues and then come back to mediation. So in my experience, where the court gives you 60 days to resolve a problem and you can ask for an extension of another 10 days, it does not work. Okay, it does not work because you need more time than that to get to the bottom of what the problem is so that these people can have a relationship after. You know, there's nothing worse than having something in your heart you want to get out. You didn't have a chance to get it out because the mediator went straight to A, B, C, D and didn't give you a chance to voice your opinion.
Well, I think now you've aired out one of the challenges of court annexed mediation. The timelines are very strict.
Yeah, very strict. That 60 days does not work for family. It may work for commercial. Maybe with the commercial they can keep that 60 days, and you'll find that in my experience, I find that there is a difference in mediation as far as court annex and the way I would say I do mediation. Okay, within the court annex mediation, through my experience, I find that it's mostly negotiations. You're not mediating. As I mentioned before, you've got the issues and you're going to negotiate what the issues are. Okay, in family, you have to go right to the root cause of things. Okay, you'll find that, people behave in the way they behave because of the fact that from they were little, let's move away from a marriage for a minute and get to the family. From they were smaller siblings, they got something going. Maybe mom liked you more than me, and we grow up and we have that kind of of dispute. So when you get into things like succession, you'll find that, my gosh, these guys cannot, they do not want to come together to save the family's possessions. Why? And that's because from they were younger, they did not get along. So now you've got to take time out, send them to the psychologist to deal with that, and at the same time, you cannot lose your mediation because you'll find that time frame that you say, okay, fine, you go to the psychologist or you go to the doctor, you come back, you lose the person. Sure. So the court is not really concerned about that. The court is concerned about, okay, negotiate and you give us
the decision.
And out it goes.
Yes.
So once the court gets to clear its backlog, I think they're quite happy with that. However, access to justice, to me, will be successful once they clear that backlog and close the front door, so that no more cases will be coming through the courts. Because if you take 2 steps forward and 1 back, that backlog will continue to be there. So just negotiating and clearing it will just bring that problem back to the court again.
Yes, and I've actually, maybe we could also say this is true. Sometimes in court annexed mediation, some people will actually make it fail intentionally so that they can go back to the court for the court to decide.
Yes, that's true, and that's because you'll find that there are some cases that we refer to as a deep pocket. Okay, so it will not make sense for mediation to work in that situation.
Yeah.
For example, if you get, let's say you get a multinational, okay, you know the money is there. So why now settling mediation when we can take this to court and we can actually get more money than you'll actually settle for a mediation?
Yeah.
I think, the way the system works is that, as we talked about the expense of litigation, the longer you take, the more money is spent.
Yes.
So time is of essence.
Yeah.
Now, when you look at those files that they do not want to settle, you'll find that the time is money. So there's money sitting there, and people are saying, you know what? No matter what happens in this case, the money will be there.
Yeah.
Whereas in other cases, the guy may go broke,
Yes.
see, and he can't pay you. So you want to settle. That's an incentive to settle. But with the bigger cases, you just let them ride out, and they're very difficult because of the money involved, and because of the fact that sometimes they meet. The board meets once a year or twice a year, and the lawyer, the agent, cannot make that decision for the individual. So even though they come to mediation, the lawyer might say, you know what, we got to wait for the CEO to come from Germany or from the US and have this meeting before we agree. We only authorize to settle for so much. Okay? Anything more than that, and people say, no, I think that's little because I know you have the money. So I'll wait you out. So those are the kind of issues that we have with
Mediation.
with mediation, yeah.
Okay. Now maybe we could talk about your private practice in mediation. Now you tell us how you practice, as you said, your family mediations, or the company that you practice under.
I practice under my own banner, Daniel's Mediation, an alternative dispute resolution. It's an organization that we try to make it a one-stop shop, where we have a lawyer on staff, we have retired judges on staff, we have arbitrators on staff, and we have a psychologist on staff, and we also have a social worker and an educator on staff. The educator is there for the children. Okay, she's a former school teacher trained in Canada, and she lately joined our firm. Why is this one-stop shop? Is because in ADR you will find that there is mediation, and there is arbitration, and there's reconciliation. But the two major ones are mediation and arbitration. Now, what we try to do what we refer to as med-arb, okay? Where you would come to mediation, and it works well in family, okay? Where we would sit and we would try to resolve certain issues. But we will get to one issue that they are now at loggerheads. They will not move. So when they come into the office, we have them sign an agreement that if mediation fails, we will then go to arbitration. So we keep what has been resolved in mediation for the agreement, and we send them off to one of our arbitrators, and he arbitrates, or she arbitrates that issue. Then once they come to an agreement, we put both agreements together, and that's what we produce now as a final mediated agreement.
Okay. And maybe now you could also say about the trainings that you usually have and the upcoming ones that are around the corner.
Yes, we have a training coming up next week. You can contact us at 0704-913-160, or you can visit our website at www.dms-adr.co.ke. You'll find all the information there in regards to our training. Now,
The dates?
The date is we start next week, Monday the 14th, and we run until the 19th, I believe it
Of
is.
December.
On December, yes. What we do in our trainings, mediation training has not changed in the last 25 years when I took my family mediation course. There's still an element of emotional intelligence. There's still an element of support for the child and for the parent, for either parent. There's still an element of parenting that you need to go through. So the course itself and most mediation courses is the same globally.
Yeah.
So what we try to do, we try to have a Kenyan syllabus
Okay.
for Kenya.
Yeah.
Okay?
Yeah, tailor-made for
For
Kenya.
Kenyans, that's
Yeah.
right. We can tailor-made for the police, we tailor-made for any organization that needs our services. However, I believe that Kenyan mediators must be trained by Kenyans.
Yeah.
Unfortunately, we do not have the capacity to get our courses accredited in Kenya. I think the only people that are accredited in Kenya right now is the judiciary. Besides judiciary, no one else accredits in Kenya. So what we try to do, we try to collaborate with organizations. For example, we would collaborate with Kabarak University. And the reason why we love universities is because we feel like if we can get to the youth, okay, to the young lawyers, that before they go into, or when they go to the School of Law, from law school, they can now take some mediation in the School of Law. So we try to push the syllabus that we would like to see Kenya School of Law changes to from litigation to mediation, and then send the students out there. In my opinion, litigation is on its way out. People are getting smarter these days. People don't want to spend that kind of money and know, as we put it, it's just a dress rehearsal. I mean, you'll go through all these affidavits and petitions and discovery and disclosure just for the lawyers to sit down and settle at the end of the day. 5 years later, okay, let's make a deal. It will never get to court. The judge will never see it. And you've gone through 5 years, hundreds of thousands of shillings,
Millions,
and the lawyer is going to settle there, you see? So we try to get these young people to know the value of mediation. If we can get the schools from elementary, you know what, I do some teaching at one of the local international schools in Kenya, and we have every year, and I believe the Kenyan schools have it too, what they refer to as Model UN. Okay? That is mediation. Those kids are going to the UN to learn how to mediate the difficulties and the problems in the world. They're not going to this litigation anymore. So if we can train kids from the high school level, or even the primary school level, right through university, right through to the Kenya School of Law, I think that will be a good thing.
Yes, for sure.
So when we try to train in mediation, we do things with the Kenyan institution so that it can have the Kenyan touch, as you say. For example, when we do most of our family training, we do with Hekima University, with the priests, and they will take you through the family. And when they speak of the family, they'll take you from Adam and Eve. And the first law that was there, thou shalt not eat from this tree. And from that one law, went to the 10 Commandments, and how complicated society got for the laws to change. And because it got complicated and the laws had to change, we moved away from mediation now and start making money off society's woes, as they say, rather than keeping the mediation in place and continue for it until today. continue with it until today.
Yeah.
So, you know, we really try to put the Kenyan touch. I don't like this, Canadian judges coming in, or this one's from UK is coming in. No, I think the talent is in Kenya, and we got to use Kenyan talent. And that is why I got people like Justice Oluwatch and, you know, Judge, what's his name? Judge Limo Doga.
Yeah.
I got them on my panel because I want that Kenyan feel. I don't like, well, I like Europeans, but I don't like them teaching us what to do in Kenya.
Yeah. Yes, thank you so much about that. And actually, I remember while you were training how also my former lecturer at Kabarak, actually he's still a lecturer there, Justice Otiso.
Yes, he's also on our panel on Daniel's mediation.
Yes.
He does our arbitration. He's one of our arbitrators, as a matter of fact, yeah.
Yes. As we are winding up, you could tell us about the future of mediation in Kenya. You've mentioned that Kenya School of Law should actually embrace alternative dispute resolution. And I think in one of my videos, when I talked to the assistant director, I think I'll put it in the link, she said that actually they're also thinking about that. She feels that the syllabus of Kenya School of Law should be revised. But in general, what is your perception about the future of mediation in Kenya?
The future of mediation in Kenya, as I see it, there's a bright future. Okay, there's a bright future. The Constitution was a good start, and I believe now we've got there's a bill, mediation bill, that has reached Parliament that they'll be voting on very soon. From that point, I can see where we can move towards getting a mediated clause in our agreement. Something that will say if any dispute arises over this agreement, you will attend mediation. If mediation fails, you'll attend arbitration or med-arb and close it there. You see, that way the courts will be able to close the front door. There'll be no more files coming in. There'll be only the files going out to clear that backlog.
Yeah.
Okay. Yeah. So once we get that in place, you will find that the costs, access to justice, would become something tangible.
Yes.
Because once that happens, you will find that the next step, through my experience with mediation, the next step that's going to happen from here is self-representation.
Yes.
I mean, take a look at family mediation. Once you've resolved child support, custody, parenting, schooling for the kids, once you resolve all that, what else is left?
It's just maybe now the divorce.
That's it.
Yeah.
So to drop those divorce papers,
It should be an easy task.
I'm sure in the next couple of, within the next year or so, I haven't heard anything on this yet, but I'm sure those, what you call them, those forms will be online.
Yes.
Someone will come up with the idea, I'll put all the court files online. You just go there, fill it in, push a button, it's gone to the court. Someone prints it, look it over. We agree, they've been separated for so long, everything is taken care of. The mediated agreement is attached to this. Here is your decree nisi. Done.
Yeah.
So the more people see the savings in time and cost, the more they'll move towards mediation.
Yes.
And Kenyans are very, very, how would I put it? Kenyans are very, very astute in grabbing onto those opportunities that can make them a shilling. As soon as they see we can save money there, they'll be all going there.
Yes.
All we need is that legislation to be, or that mediation clause to be put within all our agreements, and I think we'll be good to go.
Yes, and I've forgotten a very important aspect. Maybe you could tell us if your company also does this, workplace mediation. I think as you're saying clauses to be put in mediation, I also feel in workplaces instead of employees or employers always taking their disputes to the Employment and Labor Relations Court. I think they could also consider mediation.
Right. And not only for the dispute between the employer and the employee, but you also have disputes between two key employees.
Yes.
You can have two directors that are really going at it, and that may stop the way production happens.
Yeah.
You'll find that his group won't cooperate with my group because you and I are not getting along.
Yeah.
So I may need something from your department, and you tell your people, let that one wait. So you need that mediation to, or you need your managers to train in mediation in the workplace, where they can handle those disputes between those two key employees, rather than, which is also important, rather than employee-employer type of relationship. Okay? So the employees themselves, what we refer to as self-mediation, the employees themselves got to resolve disputes between them. Because most of the disputes, that's where it is. The other one with Code 2 and that stuff, those are really big. Or when someone gets fired, I worked there for 20 years, I didn't get my dues. But when you have the company losing money because the two major directors working on a major project, not getting along and stalling things, you're losing money, then you need mediation because you need both employees. You cannot let one go or let the other one go. These are your generals, as we call them, you see? So you got to keep both of them. So that way, workplace mediation works twofold, with employer-employee and within employees themselves.
Okay. And does your company also maybe offer such kind of services?
Yes, we do. Yes, we do. We do training for organizations in Nairobi, exactly on what I just explained to you. We train their managers, and we get them keeping the dispute within the organization. Lately, what we've been trying to do, we are trying to get organizations to contact the other organization through their law firms, and instead of going to court on a matter, it's resolved in the workplace.
Yeah.
Okay? So I would call you, we'd have a dispute, and I would call you and I would say, hey, why don't we call justice to mediate this? Okay, so company A, company B, okay, fine, we call justice, and justice comes in to her office, first one session in my office, next session in your office, and that way we're not running to court, keeping things back again, and spending all that money and losing all that time. We resolve it right there, and we're good. The CEO is sitting just across the hall. If we have a problem that we may need to settle for more, you just tap on his door and say, hey, these people want $1 million, but I'm authorized to 800. Give them the extra 2,000, get it over with. Yeah. So it works great that way also. When we have in-house, we refer to it as in-house mediation.
Okay. Now as we are finally winding up, you could also just say your parting shot and your final words on mediation.
Well, I think I said my parting shots already, because I think that I'm very passionate about mediation being access to justice being put to the people. Okay? Right now, what we have is access to justice through the eyes of the judiciary.
Yes.
And we have not reached a point where we can tell Wananchi, you know what, you do not have to go to a lawyer's office. You can go to a mediator's office. And the court will now find a way, which one of the issues I have with the courts, but that's my personal issue, where we cannot file these out-of-court mediation. So the judiciary needs a registrar or a registry.
Yes, registry. Yeah.
Where if we come with an out-of-court mediation, we settle, we sign, okay, fine. In case of breach, it will be not treated as a breach of contract. But for the purpose of filing and holding on to these documents, you go to the court and say, we'll put this to you.
Yeah.
What I do now, I tell my people, we will not need this agreement until someone breaches it and you want to go to court. Okay? But it's inside my agreement when we mediate that if any conflict arises, you will come back to mediation. So if he agrees to pay you child support for each child of $250,000 for a total of $500,000, and God forbid we get something like Corona and he cannot make that payment. You don't run to the court and say, hey, he's in breach of contract. No, you come back to mediation and we'll work something out. Now, if you're not happy with that, then you go to arbitration.
Oh, yes.
You don't have to go back to the courts. Just imagine how much money we would save.
Yeah.
If that court, we would just look at my vision, where there's only two courts in society, the constitutional court and the criminal court.
Okay.
Just imagine that. All these commercial stuff and civil stuff, we settle on our own. Mediators are out there to do that for you.
Yeah, for sure. I mean, it will save a lot. And
It will, even for the society on a whole. And we can use that money to put into things like children's education, where we'll teach them the most important and the fundamental parts of mediation, and that is communication.
Yes.
Communication is what? Listen, speak when you're supposed to speak. Listen, speak when you're supposed to speak. You listen.
Yeah.
Okay, too often we're trying to talk at the same time, and we don't get anywhere. So if people learn to communicate, life would be so much easier.
Yes.
And what is mediation? Mediation is communication. That's what we started off by saying. It's just two people communicating. And because they cannot communicate, they need that human buffer to assist them now to communicate.
Yes. Wow. It's been a pleasure having you.
Thank you very much, Ms. Ogola. Nice speaking with you.
Yes, I also want to thank my viewers for tuning in. And in case you missed any other video on legal matters, you can just check. All my videos are produced on legal matters. Thank you.